Good morning. Barb Teachblade Reynolds here. Just got through looking at a Periscope live stream with Mitch Jackson, who is out in Laguna Niguel in Orange County, and absolutely beautiful sunrise that I enjoyed with him and about 40 other people from around the nation who were observing that. And I thought to myself, that's absolutely great. Mitch is in Laguna Niguel, where the temperatures are perfect for him to have a long sleeve shirt on. But here in Tehachapi, where I am, we're expecting snow this weekend, so we dressed accordingly here in Tehachapi. This is the 330 video series, a weekly video series, 3 tips in about 3 minutes for paralegals specifically, but everyone in the legal community generally, and wanted to talk about the importance of client intake and interviewing, the initial interviewing process as it relates to personal injury clients, prospective clients. Very important process, and here's why. Tip number one: the lawyer's job is to get as much money as possible to make that client whole again. That client's life is in critical mass. It's been devastated because of the injuries they've received, the loss of income, the cost of medical expenses. So it's extremely critical to get a handle on the amount of damages because, frankly, one, that's why the lawyer takes the case in the first place. If he can realistically compensate that person and attempt to make them whole and make some type of profit for the law firm, that constitutes both the attorney and you as the paralegal in the law firm. So it's very important to get a handle on those things. Um, if you have the competence, then the lawyer has the confidence in you to allow you to handle that very critical initial client intake and interview. Tip number two: in settling down with the client comes in, that client is in a state of emotional upheaval. They're injured. They're thinking about what's going to happen to my future. It's so much about their life at that point. They just don't understand and appreciate. And as one of the first responders in the office to those kinds of questions, it is absolutely essential that you are on your game. You're going to sit down with the client. You're not going to sit across from them. You're going to sit beside them or sit near them so that it's not an official, a confrontational kind of setting, but a very inviting, warm, and understanding. I feel you kind of an interview process, and in that process, you get to learn a lot more about the client, what the issues are, because they're more relaxed. Um, some of the questions you certainly have to. Oh, one more point. Don't have them turn toward a door. Why? Because doors are distracting. There's activity going on in the hallway. People are walking by, and it takes them off their game as you finally gotten them into a mode of comfort and being able to recall the details of the events uh, surrounding the auto accident. Um, number Oh, that's still part of number two. Okay, the kind of questions you're going to ask them. What's the date and time of the accident? Was it in the evening? Was it on a weekend when there's more cars, less cars at a particular time on the weekend that are on the streets? Was it doing rush hour traffic during the week? Those are kind of things you want to figure out, because it goes to the issue of liability, speed conditions, culpability. So find out what is the date and time of the accident. Where did the accident occur? Because you've got to get a copy of the police report, and depending upon which, whether they're in a city, In our case, the Tehachapi City Police Department would be contacted, or if it's in the county, then the Kern County Sheriff's Office would be contacted. So where the accident occurred is very important. When the client finally signs a contingency fee agreement, you're going to also have them sign an authorization which authorizes you to obtain the police report, to obtain any kind of lost pay records from their employee, from their employer, in order to gather the specials and the documentation that you need for those specials. So, excuse me. And what's a contingency fee agreement? It's an agreement that lawyers enter into with the client in anticipation of handling their personal injury matter, their property damage matter as well. And usually, if the matter settles and it's between 33 and a third or 40% that the attorney takes, if the matter has to go to trial, then it's probably somewhere in the area of 50 to even 40 to even 60%, depending upon the complexity of the matter and obtaining the best result for the client. Um, Hence, there is a significant financial outlay for attorneys because they're taking it on a contingency fee basis. If there's any upfront costs in it, they're de minimis. But usually, the personal injury attorney takes that case on a contingency fee basis, banking on that case resolving and settling or going to trial and resolving with a raise that will adequately compensate the client, as well as some residual for the law firm and the paralegals that also work with that firm. Was it raining? What were the weather conditions? Was it raining? Was the road slick? Were there potholes in the road? Were the stop signs up? Were the stop signs visible? Was there a red bottle brush tree with its blooms that was near the stop sign, and therefore the stop sign was obscured? Those are very important elements to determine what the environment was like on the date of the accident. Were there any storefronts around where someone could have observed the accident and therefore become subsequent percipient witnesses to what happened and therefore take their depositions, especially if they're older? You want to take those senior citizens' depositions as quickly as possible. Why is that? Because we don't know how long they'll be here. And if they are a percipient witness to what happened, that could be a very important element in proving the attorney proving the case and getting the proper raise from the judgment. Um, was the car that your client, prospective client, was driving? Did it? Were they able to drive it away? Was the car required to be towed? Was the your client having to be transported in an ambulance as opposed to driving away under their own powers? That's critical, of course, because if there's an ambulance involved and there's more severity of the injuries, um, how fast do they believe the other car was traveling? How long has the client been off from work? That goes to the issue of their lost wages, and which is part of the specials. It's part of the damage issue. And the lawyer is always looking for that damage issue. How much can he parlay this into a sizable raise, RES, a sizable raise resulting from settlement or the judgment? There's also, third tip, the statute of limitations. 2 years from the date of the accident, the client has that time in which to sue, or the lawyer to sue for personal injury and property damage. The statute of limitations for property damage is 3 years. So 3 PD property damage, 2 years for a personal injury, and that case must be filed in the court, or that client forever loses his or her rights to sue for those personal injuries and property damage. And if that date is missed, then we do hope that the law firm's medical malpractice insurance is paid up. The if the lawyer decides that he or she can't do that client enough justice, because the deadline is coming. There's not enough time and resources to handle the case as effectively as the lawyer would like, and therefore he or she may decline representation of the case. In that case, it is absolutely critical that a letter be sent to the person advising them of the decline of representation on behalf of the law firm, and at the same time reminding them that they must file their lawsuit by a certain date, that there are 2 years in order to file for personal injury damages, and that it's 3 years to file for property damages to the car. This is, as you can see, personal injury matters are very critical, and you can play a vital role in getting that damage issue under control, because based upon your notes from the initial client intake review, that lawyer is going to make a determination as to whether or not he or she is going to undertake representation in the first place. So you want to pay close attention to that. Personal injury cases give you such joy, and I fondly recall that in helping people who are not only devastated because the legal matter comes up, but they're physically devastated, and they're therefore emotionally and mentally devastated. So it's a critical time for you to just jump in there as a paralegal and be the champion, and the clients will embrace you, and of course, the lawyers will absolutely love you, and that's exactly what you want as paralegals. So those are the 330 series I'm concluding this morning. I will see you next week, and in the meantime, make every day your masterpiece. Take care, guys. Bye bye.